Hi, everyone. Welcome to the midterm review. As you can see, I've made a presentation for you all. This will be available on Blackboard, but this video is also kind of the highlights and the main points. So bear that in mind. And here we go. So, not that it should be obvious, but some of the things that we're going to talk about in this overview is the big important things. Not that other things that weren't in this aren't important. It's just these are the things that are going to be relevant to the midterm. So it's important to remember what is a crime. Remember that crime itself is an act committed in violation of a law prohibiting it or omitted in violation of a law ordering it. It's the reminder that a crime is pretty straightforward. It's something that is deemed illegal. And we also know that all crimes have certain elements. We know that there's a criminal act, criminal intent, and concurrence of the two. And if we remember, a criminal act can be a physical act or not acting when supposed to. Intent is the reason behind it, and concurrence means that they are both happening. So when we talk about intent, it's important to remember that there are 4 categories or states of intent according to the Model Penal Code. That is purposely, knowingly, recklessly, and negligently. Remember, purposely intent or purposeful intent means that the exact intention, the reason behind committing the crime is exactly what happens. Knowingly is that you know that there is a potential negative outcome, not necessarily the exact purposed outcome, but you knew a bad outcome was possible. It was knowingly possible that you did this. Reckless intent means that you were aware of the dangers, but you chose to ignore the dangers, not that you were purposely trying to do it, but you ignored the warning signs. And negligent, where you just simply, for one reason or the other, were unable or unaware of the consequences or of the direct results. And so remember, one of the other things that's important to note is the theories of punishment. Remember, when we're talking about in criminal justice, when we're talking about punishment, we don't necessarily mean, physically harming someone. No, we mean punishment as in what is the consequence for being found guilty. And so our theories of punishment are retribution, incapacitation, deterrence, and rehabilitation. And remember, retribution is the most like punishment as we understand it, where you do something and you get some kind of direct response in return. Incapacitation means physically holding. This looks like incarceration, placing somebody in prison. Deterrence, the theory of this punishment is that you are stopping future criminal behavior from happening through deterrence. Your punishment is severe enough that other people won't want to commit the crime. And then rehabilitation is that reform aspect, the idea that through several different modes and ways of operating, that the overall outcome is not just to punish you, but to make you a full-fledged and fully functioning member of society once again. So remember that in all of our conversations so far that we've had in our lectures, we've been talking about law. That's the focus of this class is criminal law. And so we need to remember that there are multiple sources of law. And generally there are 3 main sources that we use as our sources of law in this country. We have constitutional law, statutory law, and case law. Remember, constitutional law is the things that are written out in the U.S. Constitution, as well as in each individual state's constitution. These are the things that are immutable rights that we have. That is the primary source of law. It's the thing that determines whether or not anything else can be a law. Is if it violates a constitutional right, it cannot be a law. Statutory law is the written and published laws. These are the things that are passed by legislative branch and goes through Congress and the Senate. These are the things that local municipalities do. These are the things that we all understand as the basics of law. When we talk about breaking the law, we're really talking about statutory law for the most part. Constitutional law is our source to say what can and can't be. Statutory is what is written. And case law, that's the one that's from the lawyers or from the judges. They're the ones that look at decisions and go, we need to make an overall statement. Case law works really close with constitutional law because it's where judges, typically on the Supreme Court, see what's previously been said and make large sweeping judgments. Remember, case law is precedent. It's the ideas and rules for how to proceed with certain cases. Please note, these are the three generally accepted sources of law, but also remember that law comes from people who are elected, and people who are elected are people that have different religious backgrounds, faith, different cultures, different ideas. A lot of laws are also based off of what culture says at the time. If we develop our culture in a certain way, we change what we consider illegal and not. So it's important to keep that in mind, that these are the three generally accepted sources, but there are more than just these. So remember, when we're talking about crimes, much like we said with laws, crimes have different levels. We call this grading of crimes, and we grade them based on the severity or the importance of that crime. So the more serious and heinous crimes are considered felonies. They're the highest importance. Then we have felony misdemeanors, which can depend on jurisdiction. Then there's misdemeanors. Remember, misdemeanors are less serious, and I put air quotes around that, than felonies. Misdemeanors are still serious crimes. There's things like robbery. There are things like theft. Arson is typically a felony, but can be a misdemeanor if it's a small end fire that doesn't do a lot of damage. But the idea is that they're still serious crimes. Infractions and violations is the lowest level, and these are the things like speeding. These are the things like jaywalking. These are the things like not paying a fine. The infractions and violations are the lowest level of crime. They're typically things that we might consider victimless crimes, which we'll get way into later, but this is just a review for the midterm. So when we grade crimes, we're looking at felonies, we're looking at misdemeanors, and we're looking at infractions and violations. Okay? That's the big important piece. So it shouldn't be a surprise that there's going to be a question asking about the differences and similarities between civil and criminal law. As I've said at the beginning of the class, criminal law is the focus of what we are going to be talking about most in this class, so most of the things we've already talked about are criminal related. But remember, the big difference is that civil law is focused on private rights of individuals. It's one-to-one. Criminal law is looking at violations to society. So criminal law, the reason why they're called criminal is because they impact a large majority of people, not just one person. So remember, they're very similar in how they're structured, but they have different outcomes, and they use different terms, and there's also a different level of proof that's required, which is its own separate thing. But it's important to note that criminal law is the big focus of what we're focused on, and that's breaking the law and doing criminal actions, where civil law has to do with individual person-to-person or business-to-business problems. So, very briefly, I just want to remind you all the legal system in the United States is a dual federalism system where there is one federal government and 50 individual but equal state governments. And how that works is that there are federal laws that regulate the country as a whole, and then the state laws deal with their own things within their borders. So the state laws can't supersede or go over the federal government, but the federal government doesn't get super involved with what each state does. They just set the rules for the whole country. So I will tell you right now, there's a question asking about Article 1, subsection 8 of the Constitution that asks that states what Congress gets, what powers they get from the Constitution. And remember, these are the big things. You can find them on any actual documented version of the Constitution, whether that be through the official government, which I'm not sure if it's still available or not, but they do say that the basic powers of Congress are to regulate currency, establish post offices, promote sciences and arts through regulation, declare war, raise armies, conduct foreign affairs, regulate interstate and foreign commerce, and make laws necessary and proper to execute other powers expressly granted in the Constitution. So, remember, there are three branches of government: the legislative branch, the executive branch, and the judicial branch. Remember, the legislative branch is Congress, which is the House of Representatives and the Senate. This is the lawmakers that are elected by officials for each state. Remember that the House of Representatives and Senate have a different number depending on, well, every state gets 2 senators, and each state gets a different number of House of Representatives depending on their population. I'm trying to remember that directly. But remember that legislative, their primary job when it comes to not just the powers that is granted to Congress, but their job when regards to law is they create the statutory laws. Remember, we said statutory law is the big body of law that we understand. That's the legislative branch's job. The executive branch is the president, which that branch of government's job is to enforce the laws. So that means they're in charge of the policing branches. And then there's the judicial branch, and that's the Supreme Court. That's the court system. And their job is to interpret the law, to make sure that when they say this is a law that was written by Congress, they also are telling us how we should be interpreting it, how we understand it, what kind of punishments there are, things of that nature. So, another thing to remember is that when a decision is made, a guilty verdict happens. It is a constitutional right of a defendant to appeal their case, where they ask for certiorari, which is the power to seek judicial review. And if an appeal court does, in fact, take a case, they have 3 possible actions for any appeal. They can affirm, they can reverse, and they can remand. Reminder that affirming an action or affirming an appeal means that they're agreeing with the earlier court's decision. Affirming means they are agreeing with the lower court's decision, so they agree with what the original case was. Reversing means that they disagree with it and they are going against it. They are saying, if you were found guilty, we find you not guilty. Remand means that they notice that there is some issue in the process that wasn't followed properly, and so they send it back down to the lower courts with rules. So now they have to do something different, but they're not changing the outcome. They are simply saying that the lower courts need to readdress this and figure it out with these new standards. So, affirm means to agree with the previous, reverse means going against it, and remand is sending it back down with new instructions. So, we need to talk about burden of proof. The burden of proof is something that we talked about a little bit at length and I'm not going to go super deep into it, but I did bring all those slides back in here with a little bit of change. So the important things to remember about burden of proof is that, number one, it's the party or the individual's responsibility to prove a charge, allegation, or defense. That's what burden of proof is all about. It's the responsibility to prove something. Now, the two components of a burden of proof are burden of production, burden of persuasion. Burden of production is to present enough evidence, and burden of persuasion is the duty to convince somebody of that standard, which typically is beyond a reasonable doubt. And in criminal law, in criminal cases, it is always beyond a reasonable doubt. So, and the other big thing on this particular slide that's important to remember is the burden is often on the plaintiff or prosecutor. In criminal law, the prosecutor is burdened with the burden of proof. They have to bring the charges. They have to bring the evidence. Again, in civil cases, it's referred to as a preponderance of the evidence is the burden of proof, and it's a relatively low standard, where criminal cases, it's the most challenging level, the beyond a reasonable doubt. There is not a clear or easy definition of what that looks like. The best I've heard is 98% of the evidence proves it. 98% sure. We're talking really high standards. And remember, to meet the burden of proof, we have to use inference and presumption, where we have to make conclusions, and we can make conclusions. The whole point is to figure out whether the point can be proven or disproven. And so with burden of proof and talking about evidence, it's important to remember, and one of the things that might come up is talking about the different kinds of evidence. Remember that circumstantial evidence is things that indirectly prove a fact, whereas direct evidence proves a fact directly. And so this is where that stupid conversation, and why I brought this slide back up there. Fingerprints and DNA, things like that, are technically circumstantial because it only proves that you were there. It doesn't prove that you committed the crime. Whereas eyewitness testimony, a confession, or some kind of surveillance would directly prove a fact, so they are considered direct evidence. It's important to note, yes, it would make sense that DNA and fingerprints are direct evidence, but they are in fact circumstantial in this weird phrasing of things. But they do still prove facts. So remember, circumstantial evidence indirectly proves a fact. It's still proving something, it just isn't directly saying, yep, this is proof that they committed the crime. It's saying, well, it proves they did this, or, oh, it proves they owned this, or were here. It doesn't prove they did it. Direct evidence will always directly prove it. And that's why we take eyewitness testimony and confessions and surveillance as a direct evidence. So, I'll tell you right now, we talked a little bit, well, we talked a decent amount in our lecture about constitutional limits of Congress and laws, and one of the big ones that we talk about is ex post facto. Ex post facto laws, remember, are punishing after the fact. And so, ex post facto laws are illegal. Remember, I'm not saying these are things that can happen. These are things that are not allowed to happen. And so ex post facto typically looks like if you try to punish a behavior before the law was in effect. So you try to charge somebody with a crime that wasn't yet a crime but now is. You try to punish them for something they did 5 years ago. You can't do that. You can't increase punishment for an offense after the crime occurred. So, you caught them for a small charge. They're sitting 6 months in prison, and now we change it to be a 12-year minimum. We're upping your sentence. No, you can't do that. And you also can't increase the possibility of conviction after crime starts occurring. So you can't go, we seem to be getting more people in trouble for this, so we're going to increase the the chance of arrest for these, and we're going to increase the sentence so we can get more. You can't do that. That's what ex post facto is all about. It's trying to do more after the fact, and that is not allowed. And this is only in criminal law. Okay? Remember, the one thing that we did mention specifically about if punishment for the offense after the crime is getting worse, if a change would benefit a defendant, it is not considered an ex post facto issue. So if the punishment would decrease after somebody was already convicted, they can get it reappealed and moved down to that lower sentencing. Remember the due process clause, that no person shall be deprived of life, liberty, or property without due process of the law. In other words, things cannot be taken away. You have to be given the same equal-ish rights as everyone else. And remember, there's substantive due process and procedural due process. Substantive is that it is protecting individuals from an unreasonable loss of rights, whereas procedural is specifically from being punished without the proper procedures. In other words, a police officer can't walk up to you, arrest you, and put you in prison for the next 20 years without anything happening. No, they have to give you they have to read you your Miranda rights. They have to allow you a chance to see a lawyer. They have to allow you to make a claim about whether or not you committed the crime in front of a judge. There's all these things that are supposed to happen. This is to protect you from just being targeted, which is a whole mess. Please remember that the First Amendment, the freedom of speech, is the specific protection from the government punishing you for your right of expression and talking. But there are exceptions to the concept of free speech government punishment. Remember, free speech doesn't protect you from being punished by other people, just from the government. And our big exceptions to free speech are fighting words, incitement to riot, hate crimes, and obscenity. And remember, we did talk about obscenity. There's a test for obscenity to make sure it's not, something that is actually artistic and should be protected, but is in fact something that is vulgar for the sake of being vulgar. And excessive punishment. Remember, this is connected to the Eighth Amendment. When we talk about cruel punishment, we're talking about inhumane things. Often it's connected to the death penalty, but it does not necessarily only apply to the death penalty. Inhumane conditions, there have been arguments. This is something I actually don't think we talked about in the lecture, but something you could put in. A conversation overall is the psychology of solitary confinement, and that's actually deemed as cruel and unusual. So there are people pushing to remove that as a punishment option in prisons. But when we talk about it, our big focus on excessive punishment is things that are inappropriately or disproportionate in regards to the crime. So we're, punishing kids for most of their life for something that should only be 6 months to a year of figuring out and learning from. It's locking up drug dealers who only peddled in marijuana for 30 years, whereas they're also in there for the same amount of time as somebody who gives out way harder drugs. It's punishing people for nonviolent offenses as harsh as a violent offense. Like, this is the disproportionate we're talking about. So, right to privacy. Remember that the right to privacy is not explicitly stated in any one place in the Constitution. It's more of a combination of multiple amendments and different things. And we talked about Griswold versus Connecticut, 1965, and I've elaborated on it here. So this is actually a new piece of content that is to help explain it a little bit better. So Griswold versus Connecticut, 1965. Very specifically in Connecticut, the law was very strict about birth control use. They had completely outlawed it. And a Planned Parenthood opened up in New Haven, Connecticut. and they offered medical advice to married women who sought them out. So within 2 days, they got shut down. Just going to put that out there. This is the true story about it. They were shut down, or they were approached within 2 days of opening up their clinic. They had 10 people come in, and over like 20 or 30 people calling and making appointments. Almost all of them were married women. Very few were single. And a couple had discussed it and gone, the wife had gone to Planned Parenthood. So despite a couple seeking it out, nosy outsiders noticed that they had gone to Planned Parenthood, and so they made a mess, and that's what led to the clinic getting shut down, and the people considering the birth control getting in trouble as well. And this was a big mess, and the Supreme Court looked at all this and said, you can't have a law like that. Having a law that says essentially an adult cannot make a private decision in their own home is not a safe or fair thing. It goes against a lot of rights that we kind of have. And so they said, you can't do that. You can't tell people what they can and can't do in the privacy of their own home. So Griswold in Connecticut was about privacy and using birth control, and it has been a huge establishing part of a lot of right to privacy considerations that also go into LGBTQIA plus history, as well as many other components of this. And that's it. That is the covering of everything that I think is important to cover for the midterm. This was only meant to be a brief overview. This was not meant to be a deep dive second lecture. So by all means, feel free to use this video. Feel free to use this PowerPoint as a study guide, as something to help you through the exam. But yeah, this is it. These are the things that I thought were really important to cover based off of the exam questions. I wish you all good luck, and I will see you in the next video.